Objection! I direct you not to answer that question. Did you know that there are only 2 instances in medical malpractice cases where an attorney can ethically use that type of objection? Anybody know what they are? Yell it out. This is interactive. Okay, don't be shy. It's early in the morning. The first instance is where I ask a question of a client who's had a conversation with an attorney, something that's privilege, attorney-client privilege. Then the defense would be fully justified to say, objection, I direct you not to answer that question. The second instance is where I ask a question that's totally off the wall, where that is palpably improper. In that instance, again, the defense would be totally justified to say to his client, I direct you not to answer that question. Otherwise, in a medical malpractice case, the defense, any witness I'm questioning, is required to answer that question. So an example of a palpably improper question would be, Dr. Jones, how many times do you beat your wife each night? What? That's an example of something that's totally off the wall. In this morning's discussion, I'm going to share with you some information that even though you do not handle medical malpractice cases, and by the way, is there anybody here who does? Okay, 1, excellent. But 2, for the rest of you, I guarantee you that during the course of your career, you will encounter people who have stories. They're going to start telling you stories of woe, of tragedy, of problems that they've encountered with a doctor, with hospital staff, and you are going to make the mistake of asking, tell me what happened. Okay? And I'll tell you why I say that. So, during the course of this brief discussion, I'm going to explain to you the importance of understanding information that will help you, as an attorney who handles other types of legal matters, help the person sitting in front of you or the person you're chatting with. And by doing that, you become the go-to resource. You become the person that they look to for information so that now you and they can make an educated decision about what they need to do next. So let me give you a great example. And by the way, I'm Gerry Oginski. I'm a New York medical malpractice attorney. So as an example, let's say you do real estate law. You handle transactions involving real estate. And this young couple comes to you to do their closing. It's a first-time buyer, and now you're all excited. A month or 2 later, now the closing comes up, and at the closing, only the wife shows up. And you say, hey, where's your husband? And she tells you this story, or begins to tell you this story, about how her husband, 37 years old, just had a massive heart attack and is sitting in the coronary care unit at one of the local hospitals in Brooklyn. And of course, you being the empathetic attorney that you are, turn around and begin to ask the question, what happened? Tell me more. And the moment you begin to do that, she starts telling you pieces of information that 3 months earlier, her husband was having significant chest pain, went to the hospital emergency room, got a full workup, was told to follow up with a cardiologist, which he did, and now, just a few days earlier, he had a massive heart attack. But the facts, as she describes them to you, suggest that maybe, just maybe, a doctor or hospital staff may have done something improperly. And now the question I have for you is, you handle real estate transactions. What do you do now? Do you turn around and say, hey, listen, I don't know anything about medical malpractice. Go find somebody on your own. Go find, see if you can talk to Oginski or somebody else online. I don't want anything to do with it. I know nothing about med mal. What do you do then? What about this scenario? Let's say you handle workers' compensation. A new client comes to you. He was injured on the job. He was driving a forklift. The forklift toppled over, broke his arm. He went to the emergency room for treatment. They casted him. 8 weeks later, they take the cast off, and his arm looks like a roller coaster. And now the doctor tells him, listen, we need to take you into surgery. We need to break the bone. We need to put the bones back together with steel plates and screws and pins. And now you'll be in a cast for another 8 to 10 weeks. And plus, you're going to have nerve damage. And now you begin to get the sense that maybe the emergency room doctor did not set this gentleman's cast or set his fracture properly. You do workers' comp. What do you know about med mal that might be able to help this particular gentleman? For many attorneys, they simply throw their hands up and say, I don't know anything about this, go find somebody on your own, especially if they don't know a med mal attorney that they can refer them to. How about this scenario? Let's say you work in a moderate-sized firm, mid-sized firm, big firm, and you have a computer problem. And now the IT guy comes up, to start fixing your computer, and while you're trying to get work done, what do you think happens? You encounter some little chit-chat. Hey, how's it going? And the computer IT guy takes you literally. And now he begins to tell you exactly what's going on. Oh man, you're not going to believe this. 2 weeks ago, my father died. And you have the kind thought to say, oh my God, what happened? And now he begins to tell you a story that drags on for an hour. But by the time he's done, you learn that his dad went for a urological procedure. And his dad was on blood thinners to prevent blood clots. And before the surgery, they correctly took him off the blood thinner. So he has a surgery, and the surgery goes great. 2 days later, Dad is dead. An autopsy revealed that Dad died from a massive blood clot to his lungs, known as a saddle embolus. And the son can't understand why, if his father was on this blood thinner medication, how it's possible that his father could have died from a massive blood clot. And now you begin to get the sense of, hey, maybe somebody did something wrong. But what do? Maybe you handle transactions, maybe you handle bankruptcy, maybe you do M&A. Whatever it is, what can you do to help this person sitting in front of you? I tell you, you have a moral obligation to help this person. You don't have a legal obligation, you don't have an ethical obligation. But don't you want to try as best you can to help this person understand what their options are, what they can and can't do? Let me give you another example. Let's say you do trust and estates, and now you get a call to probate a will. And now you're speaking to the surviving spouse. And you begin to hear how this person died. Her husband was in his 70s and was a dialysis patient. And one day he comes home from dialysis, and she comes home about an hour later, and she walks in the door, and she sees a trail of blood on the floor. And that leads her right to the first floor bathroom. She opens the door up, and she sees her husband lying in a pool of blood on the floor. There's blood on the ceiling, there's blood on the walls, there's blood everywhere. The detectives who come in to examine think that this is a homicide, when in fact it turns out there was nothing of the sort. The shunt where his dialysis needle was connected ruptured as he walked into the house. And this connects to an artery. And what happened? He couldn't stop the bleeding. And this gentleman unfortunately bled to death. So now, here you are, you handle trust and estates. This woman is telling you this story to suggest to you that maybe there's a possibility that the dialysis center may have been careless in something that they did or didn't do that led to her husband's untimely death. And again, I ask you the question, what do you do now? Well, let's answer that question so that you can make an educated decision about how best to help that person in front of you, all right? So in order to answer that question, the first thing we have to talk about is, what is medical malpractice? Well, medical malpractice is really nothing more than medical negligence. Well, what's that? It's medical carelessness, the carelessness of a medical professional. Okay, simple enough. So what exactly do we need to show in order to prove that we are justified in a valid case? Well, simple. We have to show, number one, that there's liability, number two, that there's causation, number three, that there are damages. Easy enough, right? Oh, and by the way, we have to have a medical expert confirm each one of those things. So now that's pretty simple to say, but it's a little bit difficult to put into practice. So let's take a look at a question that I'm going to share with you that will help you immediately identify whether or not there may be a valid case. Because if you don't ask this one question, which happens to be a compound question, you will wind up getting a story that lasts an entire hour, and then you're going to have to filter out every minute detail that the client is telling you about, because it's just like the bar exam. It's just like being in law school, where now you have to identify the issues and filter out those facts that have nothing to do with the legal issues involved. So rather than spending all that time evaluating the possibility that they may have a case and spending an hour of your time each time you talk to someone, the one question I want you to ask them is, what do you think was done wrong, and what injury did you suffer as a result of that? So really, what is that? What do you think was done wrong addresses liability. All of these injured patients always know or have the perception of what they think was done wrong to them. Then, what injury did you suffer as a result of what was done wrong? Now, there's a disconnect. They don't always connect the injuries that they have with the what was done wrong. Many times, there is no connection, so there's nothing to go forward with. But Now they stop for a moment. It's like one of these pauses. It's like, oh crap, I don't know. What kind of injuries do I have? So by asking that one particular question, it will tell you immediately, within moments, whether or not there may be a valid case. Not always, but maybe. You know, let me give you an alternative to that one compound question. There are 4 direct questions that you could ask instead. It's like the 4 questions in Passover, okay? These 4 questions will tell you in seconds whether or not there may be a case. And here they are. When did this happen? Where did this happen? What injuries did you receive as a result of that? And has any doctor confirmed your belief that something was done wrong? Those 4 questions tell me in the span of just a few seconds or a minute whether or not there may be a valid case. So why is the first question when? Because I want to know immediately whether or not this matter is timely. Because if it's not timely, it makes no difference what their story is. It makes no difference what happened to them. We have to address the statute of limitations immediately. The second thing is, where did this happen? I want to know, what's the possible venue? Was it in a state hospital? Was it in a municipal hospital? Was it in a private hospital? Each one of those things will affect the statute of limitations. So you must know and identify quickly where it happened. Did it happen upstate? Was it in the greater New York metro area? Was it out of state? Okay, all of these things you need to know right away. The third question, what injuries did you suffer because of that wrongdoing? Now, they'll often know the answer to that. They'll go ahead and start telling you about every possible injury. And the reason you want to know that information is because you want to know, is this something involving minor injuries? Is it something massively significant, disabling, permanent? That will make a significant difference in you evaluating this possible case and whether another attorney will take on a case like that. So it's critical to understand that. The fourth question, has any doctor confirmed your belief that something may have been done wrong? Remember I told you we need to have medical expert confirmation that there's a valid case to go ahead and start a case? Not every person will have talked to a doctor who has criticized the care that they received. In fact, most don't. But occasionally, a patient will go to a doctor, whether for a second opinion, and now the doctor plays the hotshot and the hero, and he says, oh yeah, look at what the first doctor did. He screwed up. He never should have done this, this, and this. If you had done the right thing, you wouldn't have all these problems. Now all of a sudden, that doesn't confirm for me that there's a valid case, but it gives me an insight into the possibility that there may be a case about what another medical colleague has suggested, and who better than somebody who's treating the patient to give you that type of opinion. So it is very important to ask the question, because as you know, if you don't ask the question, you'll never know the answer. All right, so now we know the one question you can ask or the 4 direct questions. Either way, they're going to give you a tremendous amount of information. All right, so how many of you know, by show of hands, what the time limit is to bring a lawsuit here in New York for an adult in a private hospital? Shout it out. Excellent. Great. We have some people who are participating. Wonderful. Thank you. Yes, it is 2.5 years from the date of the wrongdoing in which to bring a lawsuit for an adult in a private hospital. All right, let's change it up now. How about in a municipal hospital for an adult? How much time do they have to file a notice of claim? Say it again?
90 days.
You are correct. You have 90 days in which you must file a notice of claim from the date of the wrongdoing. How much time do you then have in which to file a lawsuit against a municipal hospital?
1 year and 90 days.
You are right again. 1 year and 90 days from the date of the wrongdoing. Okay? Now, let's change it up even more. Because as you know, with every general rule, there are exceptions. And statute of limitations have many of them, especially whether you are an adult, whether you are a child, whether this happened in municipal hospital, private hospital, so on. Let's say, for example, this is a wrongful death matter that occurred, let's say, Cornell, okay, private hospital. How much time does the surviving family have in which to file a lawsuit? Anybody? 2 years from the date of death against a private hospital. Now let's shift back to a municipal hospital, like Elmhurst Hospital, Jacobi Hospital, Bellevue Hospital, Kings County, Queens General. These are all municipal hospitals owned and operated by Health and Hospitals Corporation. So, in a wrongful death scenario, how much time does a surviving family have in which to file suit against that legal entity? You already know the answer. It doesn't change. 90 days from the date of the wrongdoing in which to file a notice of claim, which, by the way, is a prerequisite to going ahead and starting a lawsuit. And how much time do you have to file suit against a municipal hospital like Bellevue? The answer is correct, 1 year and 90 days from the date of the wrongdoing. So it is far different. All right, let's change it up again. Let's say mom is having her first child, and now she's in labor. She's now at Columbia Presbyterian, and during the course of her labor, she now encounters complications, and the doctors there fail to recognize that the baby is in distress. The baby is suffering from a lack of oxygenation, and now they don't recognize this quick enough, and they don't do a C-section. They allow her to labor and to deliver vaginally. The baby is born severely depressed, respiratory depression, and it turns out the baby is ultimately diagnosed with significant brain damage and ultimately with cerebral palsy. Permanent damage to the baby. How much time does mom have in which to bring a lawsuit against a private hospital here in New York? It is, I'll tell you, just give you a hint, it is markedly different. Say it again? It is many years. It is much more than the standard, much more than we told you was the general rule. The answer is 10 years from the date of birth. Okay? Significantly different. But now let's jump back to the municipal hospital. So let's say this happened at Kings County Hospital, the same scenario. You have a brain damaged baby. Now mom wants to turn around and sue Kings County Hospital. How much time does she have? Take a guess. Say it again, loudly. She's got 90 days from the date of the wrongdoing in which to file a notice of claim. She's got 1 year and 90 days from the date of the wrongdoing in which to file suit. There are slight exceptions, and there are slight exceptions if she does not timely file it, in which case we would have to ask the court for special permission to file a late claim. But that is challenging and not always successful. So, as you can tell just from this brief discussion, there are significant differences in the time frame, but you talking to a potential client where you suspect there may be a valid case here, the first thing you have to identify is, when did this happen? Was it at a municipal hospital? Was it a private hospital? Was it a private doctor's office? All of those things will immediately begin to tell you whether or not to ask the next series of questions. Okay? Fair enough? All right. Now, the next thing we're going to discuss is foreign objects. And no, I'm not talking about aliens. I'm talking about something that was left inside of you during a surgical procedure. Anybody hear of those things? It does happen from time to time, believe it or not. But the time limit in which to bring a lawsuit for a foreign object is different than for the other cases we've just discussed. Now, I will tell you that if you learn that there is a surgical sponge or a surgical clamp left inside of you, and you find that out within the standard 2.5 years, and you are an adult, and this happened at a private hospital, you've got no problem because you'd still within the time limit in which to bring a lawsuit. But before you can truly know whether or not a foreign object matter is timely is by asking a key question. And this one question will dramatically affect whether or not this matter is timely. So what's the question? The question is, was this thing that was left inside of you, was it intended to remain inside of you? Okay? And let me illustrate exactly what I mean. And it'll put it really nice and clearly for you. All right. So a gentleman undergoes hernia repair. And the hernia surgery goes fine. But as the doctor is suturing the patient closed, the needle tip breaks off. And the doctor, and it, by the way, it falls into the surgical wound. And the doctor now opens up the wound and he's looking for this particular needle tip. And he can't find it. He's spending 10 minutes, 15 minutes, he can't find the damn thing. And for whatever reason, he chooses not to get an x-ray intraoperatively to definitively see where this thing is. Finally, he decides, you know what? It's not going to matter anyway. It's not that big a deal. The patient will never have a problem with it. And already you know there's foreshadowing because I'm talking about it, right? So he closes the patient up. And for reasons that have never been explained, in follow-up with the patient, the doctor never tells the patient about the needle tip that broke off. Okay? So what do you think happens? 3 years later, the patient develops significant back pain. Yep. Goes to a doctor, and the doctor says, let's get an x-ray, see what's going on. So he has an x-ray. The doctor says, listen, you've got something in the back here. Have you had surgery recently? He said, you know, I had surgery 3 years ago, but they were working over here. How did something get in my back? The doctor says, I have no idea, but you need to get this out. Well, he agrees to have the surgery, and it turns out they got a nice chunk of a needle tip right there. And now he wants to sue the doctor. So now they're talking to you. They're sitting across from you, or maybe they're at Starbucks, or maybe you're on the soccer field watching your kid's soccer game. And you're having a conversation, and this person tells you they just had to have surgery to get something in their in their back taken out, and they think it was from the original surgery. And now you know, hey, there's a question I have to ask you. Was this something that was intended to remain inside of you? We all know the answer, right? This needle tip was not something the doctor intended to remain inside of him. In that instance, the patient has 1 year from the date of discovering this foreign object in which to file suit. Very important. Now I'm going to twist it up a little bit. Or when the patient reasonably should have known when this foreign object existed. Now what does that mean? Okay, so let's take the same scenario. It's now 3 years later. The doctor takes an x-ray. This thing is sitting in his back, and the doctor tells him, you need surgery. And the patient says, oh, no way, I can't go through another surgery. I'm scared to death. I'm worried about the anesthesia risks. I'm not having surgery. I'll live with the pain. Doctor says, okay. So now, over the next course of a year, he's taking pain medication over the counter. He winds up advancing to narcotic pain medication. Now it's almost 2 years, and the pain is agonizing. Finally, he goes back to the doctor, and he says, you got to get this thing out. Okay, they take it out. Lo and behold, it's that needle tip. Is the patient timely with his lawsuit? Well, he goes ahead and finds an attorney to go ahead and bring a lawsuit. I don't know how, but he does. And as soon as they serve a summons and complaint, guess what? In lieu of an answer, the defense turns around and says, hey, you blew your statute of limitations. And the guy said, no, I didn't. I only found out about this the other day when they took out this needle tip from me. And the defense argues, listen, when you went to that doctor 3 years after the surgery and they took an x-ray and he told you that there was something sitting in your back, you chose not to have the surgery. So what do we look at? Or when he reasonably should have known that there was something there that should not have been there. He would have only 1 year from that time period in which to file suit. This is now 2 years down the road. His case dismissed. Bad for the client, bad for the attorney. Attorney never should have taken the case. So you always have to ask that question. Was this something that was intended to remain inside of you? And again, let me illustrate this, how important this is, in a scenario involving a young couple who had recently been married. And now for a couple of years, they're trying to get pregnant. They're unable to get pregnant. So finally, they go for fertility testing. And what happens then? What happens is that, turns out, everything works for her. All of her internal organs and anatomy are perfect. He is the problem. And now they begin to ask him questions. Hey, by the way, have you ever had surgery to any part of your urogenital system? He said, you know what? When I was a kid, about 9 years old, I had some surgery. My testicle twisted. They call that a testicular torsion. And the doctor did a little procedure where he put in a stitch or a staple to attach the spermatic cord to the scrotum so that my testicle wouldn't twist anymore. And then they said, aha, now we know the culprit. Well, it turns out that the doctor who put in that stitch tied off the spermatic cord when instead it just should have been attached. And that would explain why this gentleman was unable to have children. He was sterile. So now, of course, he's now 28 years old. He now decides, hey, I'm going to go ahead and sue the doctor who did that surgery, assuming he's still around, or his estate. He goes ahead and brings suit. An attorney takes that case. And guess what? The trial court throws it out. Says, your matter's untimely. It then goes up on appeal. The appellate court says, the trial court was right. You know why? Because we have to ask the question, was this stitch something that was intended to remain inside of him? The answer in this case is yes. It was intended to remain inside. In that instance, now it becomes a claim of medical negligence. And how much time does an adult have in which to bring a case of medical negligence, medical malpractice. Shout it out. Private doctor. 2.5 years from the date of the wrongdoing. Well, in his case, he was 9 years old at the time. So he would have had up until the time he turned the age of majority, plus a couple of years after that. But now look at him. He's 28 years old. This is way beyond that time. So his matter turned out to be untimely. So you always have to ask the question, was this thing that was left inside of you intended to remain inside, or was it something that never, ever should have been inside of you? Okay, make sense? Shout it out. Let's hear it. No? Doesn't make sense?
What's the difference?
Well, the difference is significant because now it means whether he can or can't bring a case.
No, but what, the fact that it stays inside of you, it's supposed to stay, why is that?
Okay, so she asked the question, why is there a difference about something that's intended to remain inside of you? Well, the law, as it's written today, says, listen, if something was put in incorrectly at that time, your clock begins to run right then and there. So the time limit as to when you can now go ahead and start suit begins from the date of the wrongdoing. However, if they now inadvertently during surgery leave an extra instrument inside and they take an x-ray and they see this surgical clamp sitting in there and it's like, holy crap, what the hell is this? This shouldn't be there. Now the law has been modified to go ahead and say, hey, you have a year from the date that you discover this to go ahead and file suit because many times patients don't recognize they have a problem until many years later.
But how did he recognize that he had a problem?
Because he was not able to have kids. He had fertility issues. They went for fertility testing. They determined that he was sterile. And that's when
it starts running?
No, in his case, when they put the stitch in incorrectly and tied off the spermatic cord. He didn't know about it.
He didn't know that.
Correct. The law doesn't care about that.
Oh, you're kidding.
Nope. And that's the unfortunate reality. So now let me share with you a different scenario also involving the time frame. You're talking to a potential client who tells you that she complained of a breast lump. And now she went to her gynecologist and made a complaint of a lump in her left breast. And the gynecologist said, you know what, it's cystic tissue. We're going to watch it. When you come back in 6 months for your routine checkup, we'll take a look at it again and we'll follow it. So that's what she does. 6 months later, during the course of the 6 months, that lump goes away, or at least it appears to go away, and she forgets about it. Now she goes back for routine follow-up, for a GYN visit, and guess what? The doctor forgets about it. Then she continues to go back every 6 months, and it's not there anymore, so she just goes back for her routine pap smear, routine visit, and checkup, and everything's fine. Until 3 years later. 3 years later, all of a sudden, this breast lump comes back in the same exact position. And now it comes back with vigor. This thing is growing fast. It's now painful. It's now leaking fluid. Now she goes back to the doctor. He looks at her. He sends her off for a biopsy. And unfortunately, she's diagnosed with metastatic breast cancer. And she turns around and says, I want to sue the bastard. He missed the diagnosis. Okay, we know that the patient has only 2.5 years from the date of the wrongdoing to bring suit. Unless, here's the exception, we can show that there is a toll. So all that really means is that we are extending the time in which she has to file a lawsuit. But can we do that? The law says we can in one instance, well, at least in this instance, if there is continuous treatment. Okay, but how do we know if there's continuous treatment? Didn't she go back to the same doctor repeatedly every 6 months? She did, but that's not continuous treatment. In order to know whether or not the patient gets the benefit of extending that time to file a lawsuit, we have to scour and identify why she went back. We have to learn why the doctor wanted the patient back. Was it a complaint that she made? Was it for a routine visit? And here's the key to understanding continuous treatment. Did the patient go back to the same doctor for the same condition and same complaint that she originally went to him for? Yes or no? If the answer is no, now you've got gaps of time that cannot be explained. And we cannot justify that there is ongoing continuous treatment. In that instance, the defense would be absolutely correct to say that we don't have a timely case. Why? Because when she went back 6 months later, after the first complaint, she didn't talk about the breast lump. The doctor didn't ask her about it. He didn't form a course of treatment to address this breast lump. He didn't send her out for a sonogram or a mammogram or a surgical evaluation. Same thing happened on the next visit and the next. So now it's 3 years later. The defense would probably have a very good shot of getting that case dismissed on timeliness grounds. So in what instance can you go ahead and show that the patient did have continuous treatment? Well, I'm going to tell you something right now. During your initial conversation with this potential client, there is no possible way you can give this person an educated answer about whether their matter is timely. There's simply no way. And the reason is you have to obtain every single page of their medical record. You have to sit with them and for a lengthy period of time go through every page of that to ask them, why did you go back? Did the doctor ask you to return? Did you get a phone call to come back? Was the doctor concerned about this breast lump and that's why he told you to come back? What was the expectation that you had? What was the expectation the doctor had about the course of treatment he was planning for you? In order to know whether or not they get that benefit of extending that time limit, you have to do a full evaluation of every single medical record. So when I say there's no possible way for you to give an educated answer, that would be true. So that simply means that now you'll have to take it one step further. I want to share with you two recent cases that came down that I included in the materials. And I'm going to read to you the court decision. Okay? One of them is Hill versus New York City Health and Hospitals. It's a First Department case, 2017. And here, the concept is important. All right? The concept says the key issue in this case is whether a patient who appeared for a planned appointment without receiving treatment represents continuous treatment to satisfy the continuous treatment doctrine. So think about this. The patient comes in for a visit, right? It's a planned appointment, but they don't get any treatment. Does that constitute continuous treatment? Well, what do you think happened? The lower court said absolutely not. And that is consistent with all the cases that have come down in the past few years. But then the appellate court turns around and says something very unusual. And it's something that put a smile on a lot of injured patients' faces. The appellate court reversed and said this: since the patient and the hospital still had an ongoing relationship that was intended to continue forward, continuous treatment is present, and the claim was timely. That is a fantastic case for patients who are looking to go ahead and file a suit when there is continuous treatment. And now here's another one that I want to tell you about. It's called Murray versus Charup. Doctor's motion to dismiss all claims should have been denied, as the plaintiff showed that the doctor continuously treated him for high cholesterol, risk of heart disease, and prescribed cholesterol-lowering medications during this period, which raised a question of continuous treatment for plaintiff's need for bypass surgery. You will learn and you will find out that any time you have a continuous treatment issue, now it really becomes a question of fact. So when the case ultimately goes to trial, the jury will have to decide whether or not this matter is timely. The jury has to decide based upon the facts that are presented whether or not there is a basis upon which to say, yes, there was continuous treatment. So this is an excellent decision, both of these, for injured patients. So now let's move on. All right. Anytime we bring a lawsuit against a doctor or hospital staff, we are always going to claim that there was a violation from the basic standards of medical care. Always. So now, what happens then? We also argue that those violations were a cause, doesn't have to be the cause, were a cause of the patient's injuries, and that the patient's injuries are significant or permanent. So, and now we have medical confirmation that each one of those cases, each one of those instances are true. The defense turns around in their answer to the allegations, and here are the 4 common defenses that show up in these cases. Number 1, why the hell are you suing me? I did nothing wrong. They argue liability, number 1. Number 2, they say, why are you suing me? I did nothing wrong. And by the way, Mrs. Patient, you did something wrong. You caused and contributed to your own injuries. That's defense number 2. Then they turn around and say, you know what? If I did something wrong, whatever I did not cause this patient's injuries. They argue causation. That's defense number 3. And then they turn around and say, you know what? If I did something wrong, and so did you, okay, maybe whatever I did caused you harm. But guess what? Your injuries really are not as bad as you claim them to be. That's the fourth defense. They're going to do everything possible to minimize your damages. So, in addition to those four, they will often turn around and say and attack us on liability and say, you know what? Don't blame us. We did everything in accordance with good medical practice. And by the way, my doctor is esteemed. He's very prestigious. He's very educated. And although he had a number of options in which to treat this patient, he used his best medical judgment, and based upon his experience, based upon his best medical judgment and his education, he chose to treat this patient that way. So don't hold us accountable. Don't blame us for what happened. And I have to tell you something. That is a very compelling argument. Juries buy into that argument all the time. And why do they do that? They do that because jurors tend to trust doctors, right? It's natural. They put their lives in their doctor's hands, and they can't often believe that a doctor would have done something so careless to have caused a patient harm and injury. And that's very significant, especially for cases that go to trial. The majority of medical malpractice cases that wind its way through the litigation system, about 80 to 85% of them are settled prior to trial. Of those cases that get to trial, the majority are won by the doctors and hospitals, the majority. All right, so let's get back on track. And now we're talking about the doctor's judgment. That is a great defense. But if a doctor has multiple options on how to treat a patient, and let's say he's got 3 options, 2 of which are within acceptable medical standards, and the other is not, well then now we're going to go ahead and argue, listen, the choice that you made was way below the standard of care, and as a result, that caused the patient harm and injury. So let me give you an illustration that will make it crystal clear about whether or not this type of defense really works. So I had the privilege of representing a young man. He was 37 years old when he went to his urologist complaining of pain when he would urinate. And it turned out this gentleman had adhesion, scar tissue, that was forming in the urethra, which is a tube that leads from the bladder out through the penis. And in order to address this, in order to fix it, the urologist had to go in and literally with a knife cut open those adhesions, those scar tissue. That's done in the office without anesthesia. And it is as painful as it sounds. It's called a cold knife urethrotomy. But I have to tell you, that was the appropriate treatment. So now it doesn't work. It's a Band-Aid procedure. Now, a couple of weeks later, the patient comes back again with the same problem. So the doctor says, let's do it again. And again, he goes in, and it's acceptable to do it more than once. And now he goes in with this device into the urethra, into the penis, into the urethra, cut open the scar tissue, and now he's fine for a couple of days. Well, a couple of weeks later, he's right back in his office. It happened again. So now the doctor turns around and says, okay, I've got a better solution. Let's take you to the hospital, put you under anesthesia. I'm going to put in a device into the urethra called a stent. Okay? It's a metal mesh stent that is spring-loaded. And we thread it through the urethra, and when I release it, it now pops open and is designed to stay open so the scar tissue can't clamp down and close up this tube. He says, great, let's do it. He has the procedure. The doctor goes ahead and he puts in this stent, he releases it, and now it opens up. And I have to tell you that this is intended to be a permanent solution. Once this stent is in, the skin, the epithelial lining, overgrows this metal mesh and now is designed to stay in place. Well, the doctor decided, you know what? One of them is okay. Let's put in a second one back to back to make sure that this thing doesn't clamp down in other areas of the urethra. Sounds good? Well, when the patient awoke, he began to complain of pain in his groin. Doctor said, don't worry, it's just normal post-op pain. Days turn into weeks. Every time this patient had an erection in the morning to go to the bathroom, he was in such excruciating, agonizing pain, he could not deal with it. A number of times he wanted to kill himself because the pain was so horrendous. He goes back to the doctor and tells him, you've got to do something. I'm dying here. I want to kill myself, literally. And I have to tell you, I've been in practice over 28 years. I have never, ever seen a doctor write in his notes, patient is in so much pain, he tells me repeatedly he wants to kill himself. That's what was in his medical notes. Okay? The doctor tells him, all right, so maybe I put in these stents a little too far in. Maybe it's hitting a nerve. Let's get you back into the hospital. And now we're going to go ahead and try and move that away from where it's causing a problem. Patient says, anything, just do it. So in the procedure, remember what I told you when I said this was intended to be a permanent solution? Well, now the doctor has the patient under anesthesia. And now he begins to put a clamp on this stent. And he begins to tug to try and manipulate it and move it. Well, what do you think has happened in the weeks since he put this thing in? This lining of the urethra, the cells surrounding it, has now overgrown this mesh. And now it has become permanently embedded, both of them, in his urethra. The doctor decides he's got to move this. So now he's tugging and tugging and tugging. And what do you think happens? It starts to tear apart. The metal strands start pulling apart. And he's like, I can't just leave it there. I got to keep going. One after the next, after the next. As he does this is sharp metal. Now these things are tearing apart the inside of the urethra. By the time he's done, what his urological reconstructive surgeon said about a week and a half later when he examined the patient, he said, oh my God, it looks like a bomb exploded in here. Who did this to you? So now we bring a lawsuit against this urologist. And the urologist turns around and says, why are you suing me? I did everything appropriately. I did everything correctly. And we turned around and said, no, you didn't. You violated the basic standards of medical care. And then they say, we used our best medical judgment. We had options. We chose the first option to do it in office, to take out the scar tissue. Okay, we gave that up to them. Yes, you're right. And then they say, putting in these stents was also a good option. We said, no, hold on. No. If you go to a doctor and there are multiple options and all of them are within acceptable care, let's say the first one, all 4 doctors would do the procedure one way and the 5th one would do it a different way. As long as it's still within acceptable medical care, he's going to win that case because then we wouldn't be able to show that there was a departure from good care. But if the option that he chose fell below the standard of care, now we can show that this was no longer a judgment call. And how do we do that? There was medical literature that was widely available to doctors throughout the country that clearly showed that this device was in fact an appropriate device to use for patients with this problem if you were elderly, if you no longer had the ability to maintain an erection. Why? Because repeated studies had shown that patients who had this inserted, who were young men, who were of the age, who still had the ability to maintain an erection, experienced agonizing, excruciating, unbearable pain. And had this doctor been familiar with the literature for using this device, this never would have happened. He never would have chosen that particular option. So this is a clear illustration to show you where we were able to show successfully that his choice was not a judgment call that was acceptable. His choice fell far below the standard of care for this particular situation. Okay? Very tragic story. This gentleman needed 1.5 years of reconstructive urological surgery. And I'll just tell you one more fact about it to freak you out a little bit more. While this reconstruction is going on, the surgeon had to create a hole for the urine to come out. And there were very few options available. Where did he create the hole? Between his anus and his scrotum. So every time he needed to urinate, he had to sit down and urinate that way until his urethra had healed up, and then they closed that hole up, and now he was able to function properly. So I use that simply as an example to show you an instance of where the defense tried to say, hey, this was a judgment call, don't blame me. We did nothing wrong, when in fact they clearly did. All right, let's move on. When you talk to these people, they will often tell you, hey, listen, I didn't have that bad a problem. I came out of the hospital with these horrible injuries. The one thing you have to remind them is, simply because you get a bad result or a bad outcome does not necessarily mean that you have a valid case or that something was done wrong. And a lot of these folks don't understand that because the only thing that they are focused on is the doctor screwed me up. The doctor did something wrong. I didn't have this problem when I went in. Now I have this problem and many others. And now they get into in their mind, the doctor must have done something wrong. Which brings me to the question of informed consent. So now they're telling you, listen, the doctor didn't tell me that I could suffer these injuries if I went ahead with this procedure. And you ask them, okay, if the doctor had told you about those risks, those injuries, would you have had the procedure? And they always, at that point afterwards, say, no, of course not. I wouldn't have done that. Really? So you're telling me that even though you needed that heart valve replaced, you wouldn't have had the surgery? Even though you needed the cataracts replaced, you wouldn't have had the surgery to allow you to try and see? You would have gone through life with a cloudy, blurry vision? Is that what you're telling me? Whenever you have a scenario where somebody tells you that the doctor didn't tell them about the risks of the procedure, if that is the only claim that they are going to make, not that the doctor violated the standard of care, but that the doctor didn't tell them about what could happen, I'm going to suggest to you to stay far away from that type of case. And the reason is because it always turns into a he said, she said scenario. Always. The patient always says, the doctor didn't tell me. The doctor always says, of course I did. I tell all my patients this. So then you turn around during a deposition and say, doctor, did you tell the patient she could suffer all of these injuries? Well, no, I didn't tell her every single one. There are hundreds of possibilities. I would be there for an hour with each patient telling them about all the risks. No patients would ever have surgery. So I tell them the most likely. And I tell them that there are still risks. And they're given that informed consent paper. So we ask the patient, hey, listen, did the doctor tell you about the risks? Did they give you that piece of paper? Yeah, some of them. Did you read the piece of paper? No. None of them. None of these patients ever read that informed consent sheet. And by the way, that doesn't mean you can't win a case on informed consent. You still can. But those are the questions you have to ask. Hey, listen, didn't the doctor tell you? So when we bring a lawsuit, we always include a claim for a violation from the standard of care, as well as, in a surgical procedure, lack of informed consent. But you never, ever want to take only a lack of informed consent case, because what's a jury going to do? Now they're deciding between he said, she said. And who are they more likely to believe? The doctor. Can't take a case like that. Okay, so what happens now when the patient tells you, you ask them the fourth question, or you ask the third question, what injuries did you suffer as a result of what was done wrong? And they tell you, oh, I have this emotional trauma, I'm traumatized, I'm depressed, I have all these emotional problems. Now, those cases sometimes do have validity. But I will tell you right now that a person who tells you that they do not have any physical injuries because of something done wrong, you are going to have a very, very challenging time proving that you are entitled to a verdict in your favor for a couple of reasons. Number one, you have to be able to parse out those emotional problems they are having now compared to the emotional baggage they started with. And that is very difficult, very challenging. And you are going to be stuck trying to deal with that issue if you delve into it where the only injuries are psychological and emotional. Now, there is an instance where some attorneys in New York will go ahead and take a case like that. One example is a woman who is pregnant, and now because of carelessness by prenatal staff at a hospital, for example, the baby dies before she gives birth. And now she has to go ahead and give birth, whether by C-section or naturally. The baby is dead. And she turns around and sues the hospital for what? For her own physical injury. And if she doesn't have any physical injury, then she can go forward with claims of psychological and emotional distress. But again, you get stuck in that dilemma. If she's got baggage, if she has prior problems, now you have to parse out to show how this aggravated and made this worse. So be wary of anyone who tells you that they only have psychological and emotional damages. And again, it's not to minimize what they went through, but from a standpoint of an attorney looking to see how they can help a client determine whether or not there's a valid case, be very wary, because that's not exactly the case that you want. So now, next. Okay. Is there ever an instance, remember I told you in order to bring a case, we have to have a medical expert confirm that there's a valid case? And when the case goes to trial, we have to have medical experts come in to support our claim. If we don't bring a medical expert in, our case gets dismissed after we rest our case, at the end of our case. But is there ever an instance that you're aware of where we can go ahead and bring a lawsuit for medical malpractice without ever needing to bring in a medical expert? Can anyone think of a scenario where that could happen? Don't yell it all out at once. There is one instance where that can happen. And I'm going to tell you about a 3-word Latin phrase that we all learned in law school. And I'm going to tell you the translation in English, and you'll all know what I'm talking about in a second. The thing speaks for itself. That's right, I heard it again. Res ipsa loquitur. But we all know the thing never speaks for itself. It always needs to be interpreted somehow. So how does this apply in a med-mal case? I'll tell you how, by an example. A gentleman goes in for surgery to have elective surgery on his right hand. He comes out of surgery with a 3rd-degree burn on his left shoulder. And he wonders, I don't understand. I had surgery to my hand that went fine. What the hell happened to my shoulder? And it turns out that during the course of surgery, the nurse was passing a cautery instrument to burn off bleeding vessels. She touched the drape. The thing caught fire. The nurses and the doctor didn't realize it caught fire until he'd already suffered a 3rd-degree burn. And now, by that time, they called in a specialist. They treated it. They put a bandage on. And now he's told to follow up. In that instance, we can all say, hey, listen, we don't need a medical expert to show that this thing should never have happened. But for the defendant's negligence and carelessness, he wouldn't have had this injury to his left shoulder. He went in for surgery on his right hand, right? In that instance, before we can use this particular doctrine, res ipsa, we have to ask one key question. Actually 2 questions. Did the patient cause or contribute to her own injuries, his injuries? If the answer is no, now we go to the second question. Was the patient under the exclusive care and control of the defense? Well, the patient was under anesthesia. Of course. He couldn't do anything. You've got the staff, hospital staff, you've got the scrub nurses, you've got the doctor. They are the ones in control of this patient, his anesthesia, his surgery. In that instance, where it's so obvious, we can use that doctrine of res ipsa loquitur to show that the defense, but for their negligence, is culpable and liable. But I will tell you one thing. You will find that the best trial attorneys in New York who have a case involving res ipsa, where they don't need to bring in a medical expert, still will go ahead and hire a medical expert and still have that expert come in and testify. Now, why would they do that? Why would they go ahead and spend money on an expert to come in and testify? Damages? Exactly. But more so on the damages, why is that important? It's important so that now the medical expert can sit in front of the jury and begin to explain to them the mechanism of how this patient suffered the injury. Explain to them what should have been done, how this thing is actually done, what the instrument is, how this never should have occurred. So it gives the jury a clear understanding, a better understanding of whether or not this thing should really have occurred. So that's why you will find that the best attorneys tend to bring in a medical expert, even though they don't need to. All right. How are we doing, everybody? Excellent. One thing that you also need to be aware of, as you're talking to this person you're meeting at Starbucks, this person you're meeting on the soccer field, this person who's telling you about their tale of woe, who are the defendants? Just keep that in the back of your mind. Ask yourself, was the doctor who treated you a private attending physician? Was it a doctor in training, a resident? Was it a nurse? Was it a hospital staff? And why is that important? It's important for the purposes of vicarious liability. You know that the employer is always responsible for the acts of its employees. And that's why you need to get a sense, not a detailed sense, but a sense of who are the possible defendants. We always bring in the hospital if it's a case involving hospital staff, because they are the employer. They are responsible. And within that hospital umbrella, there may be different corporations that are responsible for the different departments, responsible for different doctors within that hospital. So it's critical to start with the hospital, and then you delve further into what their legal relationship is. And by the way, the patient is not going to know exactly what their legal relationship is. And you won't know that till you start the suit. Okay, so what do you do now? You've now spent some time with this patient. You've learned that the case is timely. You now have identified where this occurred. Now you think they have significant damages. What do you do then? Well, remember what I said earlier? You could, if you handle these matters, handle this matter yourself. Do a full investigation, make a decision after an expert review, and decide whether or not to take this matter on. Or you can decide to refer this out to an attorney who handles this on an everyday basis. That choice is going to be up to you. So one of the things that you have to be aware of when you refer a case out to an attorney is a couple of things. The attorney's fee in a med mal case is significantly different than in a personal injury case. In a personal injury case, the fee is typically a third. In a med mal case, the attorney's fee only starts at 30% and then drops by 5% on a sliding scale. And that scale has been around since 1985, and it's not changing anytime soon. If you refer a case to an attorney and they take on that case, typically what will happen is that the attorney will give you a referral fee, but it's basically a sliding scale of their sliding scale. So if they ultimately wind up with 30% as an attorney's fee, you will get 30% of their 30%. If they get 15%, you'll get 15% of their 15%. Okay, it's just something to be aware of. In order for you to justify a referral fee, you have to show that you have performed some level of legal work. Now, what does that mean? Well, different firms interpret that rule differently. Some will say, hey, just pick up the phone, refer them to me, and I'll take care of the rest, and we'll cover you on the referral fee. Some firms do that. Other firms say, no, you go ahead and get the medical records, start to review them, send us the records, we'll take it from there. Others say, listen, we want you to be involved in the first client meeting, we want you to be involved after we review the case, and now we want you to be involved because, remember, on that retainer that goes ahead and protects your referral fee, you are assuming joint responsibility for this case. So if you do not want to share joint responsibility, then simply tell the attorney that you're referring it to, listen, keep the fee, you know, it's my pleasure, maybe you'll pay me back at some point or whatever, something else. But you have to be aware of that, and you have to make sure before you send a case over to another firm, another attorney, that you understand what the arrangement is and make sure you have that arrangement in writing. I can't tell you how many times the attorney has done it verbally and gotten screwed in the end. Just protect yourself. And likewise, make sure that the firm you are sending the case to includes you on their retainer or has you sign a separate retainer with OCA, the Office of Court Administration, because this way you are protected. And now if they turn around and say, well, what level of legal work did you perform? You can tell them exactly what it is you did. I met with the client, I sat with them, I got the records, I talked to an expert, whatever you did. Okay? So keep that in mind as you decide whether or not to refer the case out or to handle it yourself or whether to accept joint responsibility in order to justify a referral fee. Now, what happens if you, during talking to this person, decide there's no case here? I've spent an hour with them now and I've come to the conclusion that there are no damages or their injuries were not caused by the doctor's wrongdoing. And you decide, you know what, I'm not referring it out. I don't think they have a valid case. What is your obligation at that point? Well, you do have an obligation. And at that point, your obligation is to send off a rejection letter. And you are required to do it two ways, by regular mail and certified mail return receipt requested. And in that letter, you have to let the client know two things. You have to let the client know what the statute of limitations is, so that now they are again aware and it's documented they're aware. Number two, you must suggest to the client, hey, listen, I highly encourage you to reach out to another attorney right away. Because many times these people think that you are the be-all and end-all to all legal matters. And if they inadvertently take your advice and they're speaking to someone at a party and they tell them their story, now that happens to be a med mal attorney, he's like, what are you talking about? You had a valid case. You can't bring it now because it's too late. And now you've got a legal malpractice matter on your hands. So you want to make sure when you send out that rejection letter, it just has those two things. Hey, just want you to be aware, you typically have only 2.5 years. I recommend you reach out to another attorney immediately. All right. Another thing I want you to be aware of as you talk to these people. I want you to formulate an opinion in your own mind as if you were a juror sitting at trial 3 years down the road. And I want you to ask yourself, what type of witness will this person be? Is she an 80-year-old grandma who's very sweet and lovable? Is this woman somebody who's vindictive? Is this gentleman somebody who only wants revenge? Who is this person and how do they come across? And why is this opinion valuable? Because you want to know from the very beginning what type of witness this person will make if you take a case and the case goes to trial. perception is significant in any type of jury trial, as you know. So if you get the sense that this person will make a horrible witness, whether memory problems, whether their personality, now you've got a significant problem. So even though they may have a valid basis for a case, you may decide, you know what? I'm not touching this case. I'm not referring this out because I don't think a jury will ever be sympathetic and give this patient the money that the damages deserve here. So that's a really important point just to keep in your mind. And if you make the decision to refer the case out, share your opinions with the attorney that you refer the case to, because that will help him before he ever meets the client. All right. Now, another thing I want you to think about is damages. You need to figure out quickly what potential damages are there. Is there pain and suffering? Are there economic losses? Can we justify or can we show that this person lost months or years worth of earnings? Does he have a family to support? Are there kids involved? Or is this someone who was not working? Was this an elderly person? And now there's no ability to earn a living, so you only have pain and suffering. You need to make that assessment to see what are the potential damages. What about in a wrongful death case? In a death case where the surviving person, family member, is talking to you, and now they're telling you their story, the one question that I want to know right away is, was an autopsy done? And the reason I want to know whether an autopsy was done is, what was the cause of death? Again, that gives me a suggestion about whether or not there may be liability. And then we always want to know, is there pecuniary loss? What is the financial loss to the family as a result of this person's death? If they were elderly, in all likelihood, they're going to be on Medicare and Medicaid, or both. And here's the problem with that scenario. The problem is, if they are elderly, we're not working, now, in all likelihood, if Medicare paid for this person's medical expenses, at the end of your case, Medicare is going to turn around and say, pay us back all that money that we paid for his care and treatment up to his death. Pay it back. And you're like, we only got a couple $100,000. You're asking for $500,000. The family's not going to get anything. Well, I will tell you, Medicare doesn't give a damn. You are required by law to deal with Medicare and Medicaid. They have a statutory right to recoup as much money as they can. And if you ignore that, you, the attorney, can be liable for treble damages 3 times for no reason whatsoever. That's the law. So you have to deal with them, and you can and will negotiate with them depending upon how much you're able to recover. And I'll tell you quickly a little story involving a case I handled that I never would have taken had I known what the Medicare lien was. A gentleman's walking across the street, a gentleman with disabilities. He gets hit by a car, is in the hospital with massive trauma, fracture to his femur and to his head and neck. He's in the hospital for 3 weeks. His sister calls me and says, please take this case. Within a few weeks, I'm able to settle this case. There's $100,000 insurance for the car that hit him. They immediately give it up. They know they were wrong. Okay, so I settled this case within a month. But now I'm still waiting to hear from Medicare because I know he's on Medicare. They're paying for his medical bills. A couple of months later, I get a bill from Medicare saying, yeah, the bill was $350,000. I understand you got $100,000, pay up. Well, what happens in that instance is that the attorney gets the fee first, gets his disbursements. The attorney gets his fee. Who gets paid next? Medicare. They wanted $67,000. I said, if you do that, the client gets nothing. We don't handle cases like that. That's not how we do business. They say, we don't care. It turned out he had Medicare and Medicaid. So through a lot of finagling, a lot of negotiation, I was able to get them to give this guy literally a few dollars. He wound up with maybe $1,000 after all that. And I said, it was horrible. And I said to the sister, I said, had I known what the Medicare lien was to begin with, I never would have taken on a case like that because that's not what we do as attorneys. Our goal is to try and help you and make a difference in your lives. This is not the outcome that we wanted, that you wanted, and it's unfortunate. Okay? So beware in a scenario where you have an elderly person and now they are on Medicare that paid for their medical bills. Always be aware that there will be a lien. It's something you have to deal with. Yes, sir?
Does it make a difference if you try and deal with Medicare or Medicaid before?
No, they will not deal with you before. What they will do is they'll give you a printout of all the things that they paid for. And now you work off that sheet. And especially in a death case, it's finite. But now you have that information. They will not negotiate with you, and you don't have the ability or leverage to negotiate because you haven't settled the case yet. And you don't have a verdict or a final decision. So because of that, you cannot negotiate with them until you have resolved the case. Okay? Now, they are actually interested, or they try and appear to be interested, they tell us that they want, remember, it's your efforts that are getting them money, getting them paid back. So it's in their best interest to try and help you out and help your client out. But the bottom line is, depending upon how much you get, they're going to ask for the money. Yes?
They do have a statutory right to take a full settlement if they've expended more resources. However, my experience has been that they will negotiate.
Yes, that's correct. They will negotiate. They do have the statutory right to request the full amount. But again, it's in their best interest to, right, they don't want to come across as being so harsh and critical that the client doesn't get what they're, anything.
Right.
You are correct. Okay, so now, that shows you the example of how Medicare destroyed a case. So what did we learn today in our brief discussion this morning? Remember I asked you to come on this brief journey with me? You're standing in line at the bank, and now you start talking to this person, and they tell you the tale of woe. And you make the mistake of asking, really? Tell me what happened. Or now you're in your office, and now a colleague or a nurse or somebody else is now talking to you and telling you about something that happened to a friend, family member in the hospital. And now you begin to ask questions. And now the first question you ask is, when did this happen? And in your mind, you're thinking, okay, I understand now when it happened. Where did this happen? And they tell you it happened in a private hospital. And now you've got two things checked off. And now in just a few seconds, you're asking them, well, how badly injured did you get? What injuries do you have? Oh, horrible injuries. Now I've got all these problems and I can't go to work and I'm permanently disabled. That's why you're now at the bank depositing your check, right? And now you begin to formulate ideas in your head, and you get the sense that this person may have a possible case. So remember the question I asked you at the very beginning? What do you do now? Do you simply throw your hands up and say, hey, I don't do medical malpractice. I just took a class, a CLE lecture about medical malpractice for the non-med mal attorney. I don't want to deal with this. This is not what I deal with. Go find an attorney on your own. Or do you turn around and say, let me ask you a few more questions. Has any doctor confirmed your belief that something may have been done wrong? And she says, yes. And now, what do you do then? Well, now you may say, hey, let me ask you a few more questions. And by the time you're chatting with this individual, you begin to realize that they may in fact have a valid basis for a case. Whereas before this morning, you may have turned around and say, you know what? I don't know anything about med mal. I'm going to have to, tell you to go find an attorney on your own. But at least now you have the ability to help guide this client, to help guide this person, to show them a little bit about how these types of cases work, so that you are the go-to resource, so that you are the one that they trust, so that you are the one who can make an educated decision about whether to refer this case out, about whether they may have a case, about whether this is a case you don't want to get involved in. All of these questions lead up to the question I asked you at the beginning. So what do you do now? And again, that question I leave up to you. So I leave you with that question, hopefully, knowing now more than you did an hour and 15 minutes ago about how these types of medical malpractice cases work in the state of New York, what the time frames are for each different type of case, so that you, as an attorney, can make an educated decision about what to do next for your client. Thanks so much, everybody. Have a great day.